Hey, this is Shaquetta Perry. So I hope you've had a chance to read over the Working with Real Estate Agent brochure and check out the video that I did discussing that. The next thing that I wanted to talk about is the exclusive buyer agency agreement. This is the form that everyone is so afraid to sign, but it formalizes and legitimizes the relationship between the agent and the client, and it must be done before we can write an offer. So I personally prefer to have it done before we go do showings. That's just the best place that it can naturally fit, because if we do a showing and you like a property and you're wanting to make an offer, that's not a great time to have to review this agreement and sign this. We really need to be able to focus on all of the research that we need to do on the property so that we can get our offer prepared and presented as quickly as possible. So let's go through this. It's only 5 pages, and the last page actually is signatures. I'm not going to read everything to you, but there are a few things that I want to make sure that I point out. So this exclusive buyer agency agreement is entered into today's date between you and Wilkinson ERA Real Estate. So that's the very first thing I want to make sure I point out. This agreement is actually between you and my firm, even though I'm the agent that's signing off on it. So that's one thing I want to go ahead and address right up front, because one concern that people have is, how do I get out of this agreement if I don't like my agent? Well, one very simple remedy is that you can work with another agent at my firm, because the agreement is actually between you and the firm. So entered into between you and Wilkinson ERA Real Estate as the buyer's exclusive agent to assist buyer in acquisition of real property. Then we jump down to the next paragraph. The buyer represents that you have not signed one of these agreements with another firm during the time or the date that this is signed. You acknowledge as you've received a copy of the Working with Real Estate Agent brochure, and you acknowledge that you'll disclose to the firm information about any property that you've already seen, be that open houses, or if you were somehow able to get into another listing, or if you've been at model homes in new communities. The type of property, so we're looking for residential in Mecklenburg County or whatever county we're looking in. The effect of the agreement, the buyer intends to acquire a real property, and you're agreeing that you're employing the firm to be your exclusive agent, and you're agreeing that all your negotiations will occur through the firm. The duration of agency, we will agree upon the amount of time that we believe it will take to complete a transaction. If you're buying something that already is existing versus if you're building, that time frame is a little different. So we'll discuss that, and we'll agree upon a date, and then we'll go here. Compensation of firm. So this is the one protection that the firm has in this agreement. Everything else really is designed to protect the client by clearly pointing out how we're expecting the relationship to go. The compensation here, it clearly lays out how compensation works, and it is a protection for the firm. So the firm acknowledges receipt of a non-refundable retainer fee. I do not charge a retainer fee, so that is not applicable in our case. The buyer agrees that firm's fee for services shall be in the amount of 3% of purchase price of resale, new construction, land, lot, or 4% of purchase price of unrepresented seller. That will be a for sale by owner. So I am able to work with you if you are interested in a property that is a for sale by owner at a 4% of purchase price. So how do we receive that compensation? The firm shall seek the fee from a cooperating listing firm or from the seller if there is no firm. So that's why it's very important that we are aware of the properties that you're interested. One of the very first things that I will ensure is that they are offering a compensation, so that does not become your responsibility. Because if we look down at the next one, if buyer purchases property where compensation is less than the fee stated above, or where there is no compensation, then the buyer agrees to pay the firm. So in some rare cases, especially if perhaps it is a for sale by owner where someone just is not offering a compensation, then you would want to know that up front, because if a seller or listing firm is not offering a compensation, then you do become responsible at that point. And lastly, if additional compensation, incentive, bonus, rebate is offered, the buyer will permit the firm to receive it. Occasionally, there are, builder bonuses or seller incentives being offered, and we're going to agree in advance that you're going to allow the firm to receive that if it is offered. So the compensation is deemed earned under the following circumstances. If you enter into an agreement to purchase a property, then we have earned a commission as far as the agreement is concerned. If within 30 days after expiration of the agreement, you enter into a contract on a property that you were shown by me or any Wilkinson agent or any agent that was acting on behalf during the time that the agreement existed, and this serves to protect firms, really both firms, because it's typically also in a listing agreement, from having buyers and sellers attempting to cut out an agent. So if there's a property that we see while we're working together, the expectation is that you will allow us to work with you in proceeding in that transaction. If having entered into an enforceable contract, the buyer defaults. That's something we'll talk about in detail when we talk about the offer to purchase and contract, a buyer default, and what exactly that means. Compensation is due and payable at closing. So it is earned when we are under contract, and then it is paid at closing, because there are some additional services that we need to offer and complete in between the under contract and the closing time period. Other potential buyers, is very important to understand that myself and my firm are very likely representing other buyers that may be interested in similar properties or the same properties that you're interested in. And we are still required to show them those properties, even if we have showed you those properties. Firm's duties. We talked about this in the Working with Real Estate Agent brochure. It's here in the agreement just so that we have it in writing in the agreement what our duties are. Seek properties, present offers, disclose material facts on the properties. We're responsible for accounting of any monies that we receive. Maintaining confidentiality, exercising ordinary care, and comply with real estate laws. Disclosure of buyer's name and mailing address. If for some reason we come into a circumstance where a contract falls apart and there is some issue over what is supposed to happen with the earnest money deposit, if the clerk of court has to become involved, then we are required and we will provide your name and mailing address so that they will be able to contact you. Non-discrimination. Myself nor my firm, we do not discriminate against anyone on the basis of race, color, religion, sex, national origin, handicap, or familial status. And additionally, because I am a realtor, I do not discriminate against anyone with respect to sexual orientation or gender identity. Buyer's duties. So there are some things that we are expecting. We're expecting that you're going to work with our firm exclusively in acquiring a property. So a part of that would be to immediately refer to myself, to the firm, information about properties that you're interested in examining, complying with reasonable requests to supply pertinent financial and personal information. And I just want to sidebar really quickly right there, because especially if you will be seeking a mortgage, this at times can feel like a very invasive process. They ask for a lot of information, and some people become uncomfortable with that. And so it's very important to understand that there is a purpose for the information that we're asking for. And so we do need you to comply in providing that information as soon as possible. Being available for reasonable periods of time to examine properties. And I personally, I really do believe that Monday to Friday, 8 to 5, is the best time to see properties. So I really do encourage my clients whenever possible for us to see properties on their lunch, because especially right now we're in a very competitive seller's market. If you're waiting until after work or on the weekends, you may have missed your chance, your window of opportunity to see a property before it goes under contract. But we do need you to be available to see properties in person if we're going to help you to acquire a property. examining properties by appointments that were made by myself or the firm, and that's why we need for you to let us know which properties you're interested in so that we can take care of setting up an appointment. Conducting all negotiations through the firm, conducting all due diligence and consultation with the firm. We practice a due diligence period in North Carolina. That's a time where you can do any and all investigations of the property that you're interested in. And so we'll need to move forward with that, because once that period expires, some protections for you expire. And paying for all products and services required in the examination and evaluation of the property. North Carolina is a buyer beware state. The seller is not responsible for the cost of inspections, appraisals, any type of investigations that are either required by the mortgage company or inspections that you personally would like to have. You are responsible for those costs. Other professional advice, again, inspectors, appraisers. I am a real estate professional, but I am not an inspector. I am not an appraiser. There are other professionals that we will need to involve in this transaction. So we want to make sure you're aware of that, and we want to make sure that you're aware that we are not responsible for the service that they provide, even if we referred you to someone. I'm happy to refer you to someone that I've worked with in the past, but I'm still not responsible for the service that you receive with them. A home warranty. A seller may or may not offer a home warranty. If a seller does not offer a home warranty, you are able and encouraged to pursue obtaining a home warranty on your own. If there is some type of rebate or referral, if you select the home warranty company that we recommend, we do not accept that. We would credit that to you at closing. Confidentiality of offers. As a licensed agent, myself and the listing agent are required to maintain confidentiality of the offers. However, a seller is not necessarily held to that same standard if they are not a licensed agent. They may determine or decide that they want to share information about the offer. Also important to recognize that a seller is not required to disclose if they've already received offers on a property. That is absolutely up to them if they would like to disclose that information. Additional provisions, there's a space here if there's something specifically that you want to see in writing in the agreement. Dual agency is spelled out here. I'm not going to really read through this with you. This is something that we'll go over in person because I rarely run into dual agency. But there is a place here where you can either authorize or decline myself and my firm to act as a dual agent for you, and you can authorize designated dual agency if you choose. And please note that in that case, the compensation to the firm would be 6% of purchase price of resale, new construction, and or land lot, because the firm has set that price. Typically is what listing agents would have on their contract. So we just need to see that here in this agreement as well. Mediation. If there is some dispute that arises that we are not able to work out amongst ourselves, we're agreeing that we would go to mediation first, and we can agree upon which mediator we would like to choose, and we will share the cost of that mediation. Entire agreement. This is the entire agreement here in writing. There are no side deals, there are no secrets. This is it. This is everything that's in writing, and then there's a place for you to sign and give some contact information. So that's it. I hope that going through that, it's not as scary as you might have thought it would have been. It just, like I said, formalizes and legitimizes and clearly spells out the relationship between the agent